Good evening, everybody. Welcome tonight. My name is Paul Edwards. I am the Director of Training and Development, and we're very glad on behalf of the leadership of UFCW Local 770, we're excited to welcome you to our first ever COVID-19 Workmen's Compensation webinar put on specifically for our union members tonight. And what we're going to do is a brief bit of introductions and get started, but a couple of things. Our webinar tonight is being recorded, and it will be available on our website after about 24 to 48 hours for anybody who wants to listen to the information again, or for members who are unable to attend tonight, they'll be able to listen to this, and I'll say this at the end of the webinar as well for people that are still joining right now and getting on the webinar. We will be presenting this online at our website, recorded version of this within the next 48 hours. And we've found that it's very important to educate our membership on the pandemic and what your rights are. And so, as I said, we'll go through a brief round of introductions, and we've invited one of the attorneys from our law firm who will introduce herself shortly, who is our specialist in workmen's compensation. So if we can do a round of introductions, please.
Hi, I'm Lisa Wong. I do IT for the local. I'll be your tech support for tonight. If you have a technical questions, you can go to the chat box and you can chat it down there, and I'll try to help you as much as I can.
And then Erin, our interpreter.
Hello, my name is Erin. I'm your ASL sign language interpreter for tonight's webinar. Thank you.
And Amy.
Thank you, Paul. And thank you so much, everybody, for tuning in. And as Paul said, my name is Amy Leung. I'm an attorney with the law firm of Gordon Edelstein Krepak et al. And we're in Koreatown, just down the street from the Chateau office of the union. We've had a long-standing, decades-long great relationship with the union. And so we provide workers' compensation representation and assistance and guidance to all the members on a regular basis. I personally, before everything closed down for COVID, I personally go into the union at Chateau every Wednesday for consultations, which are free and confidential. And I'm a certified workers' compensation specialist with the State Bar of California. What I'm going to do today is talk for about half an hour about the workers' compensation basics, the laws, and then most importantly, which I'm sure that everybody is tuning in for, are the specific details of workers' compensation and your rights while working in light of COVID and the risks that you continue to be exposed to every day. Lisa, can I please see the slideshow? Let's see. Thank you. And so Lisa's going to go through the slideshow, and I may, veer off a little bit, but the first thing I'm going to do is give you just an overview of workers' compensation, because hopefully, thankfully, if you haven't had a work injury, you may not know much about workers' compensation, and it's this section of the law that you're not expected to know all the details, but it's actually really complicated. And so that's what I spend most of my time with counseling people is, what is workers' compensation, just in a nutshell? What are the benefits? What are the procedures involved? And so there's going to be, the first few slides may seem off topic, but I'm just going to go over the essential basics of the system. And then I'll definitely focus more on COVID-19 and the legislation that's been passed by Executive Governor Newsom, and all of the ongoing efforts that the union and everyone are in the government is doing to try to protect everyone as best as possible. So just the basic information. What is workers' compensation? Workers' compensation is a system in California, and it is a statutory system. What that means is that it's governed by the labor code, and the laws change based upon bills that pass within the California legislation. So each state has a different workers' comp system, but it's generally provides the same basic benefits. And it's what's called a no-fault system. So you don't have to prove that your employer was negligent in any way in order to proceed with filing a workers' compensation claim. In civil lawsuits, you may have to prove that, for instance, if you slip and fell somewhere, that there was a negligence, you know, a puddle of water or somewhere that was involved. But that's not the case in workers' comp. It's no fault. What the main thing is, did the injury occur arising out of and in the course of employment? That means did it occur in work during the course of your job? The main basic benefits involved in workers' compensation are temporary disability, which is a wage loss type of benefit if you have to miss time off of work on a short-term basis to recover. Medical treatment, which is provided for by the insurance company that the employer has, and they usually have a network of doctors that you treat within. And then if unfortunately you have some residual issues due to the injury, you may be entitled to some permanent disability benefits. It's not a lawsuit, and that is something that most people are worried about, is am I suing my employer? No, it's a claim for benefits, and it's something that every worker in California is entitled to, because that's the only system that you have available to you. You're not allowed to sue your employer for a work injury. So if something happens to you at work and it causes injury and perhaps permanent problems, this is the only system available in terms of getting you benefits and some recovery for that. And there are also death benefits involved within the labor code has provisions, which I'll get into further. The first step in any workers' compensation claim is filing a claim form. And the claim form, which you can find on the UFCW website, there's a link to that. You can also call us for the claim form. And your employer is actually supposed to have it available and provide it to you if you ask for it. So it's in English and Spanish. And let me just go through and the headings of each one, and because that's really the first thing, and it may be intimidating in terms of what am I exactly supposed to fill out here. In terms of date of injury, for example, with COVID-19, if you have COVID-19 exposure, you may not know obviously exactly which date that you were exposed. So you may want to write a period of time, perhaps the last month or so of your employment. You can just say approximately. And that's when they're saying date of injury, which means like when exactly did this happen at work? And if you can't point it to, then you may write a range. Description of where the injury happened, you'll want to write the location and then describe the injury and part of body affected. So in that line, make sure that you write every single body part that may be affected. Even if you think it may go away, or you may not realize it's not an orthopedic body part, it could be a side effect. It could be consequences, gastrointestinal, headaches. You make sure you include everything, because they may refer back to this and say, well, you didn't mention it in the beginning. Keep a copy and document every single thing that you provide to your employer. You fill out the top portion. You ask your manager or your supervisor to fill out the bottom portion, give you a copy of it, and they're supposed to forward it immediately to the adjusting agency that handles their workers' comp to open a file, get you assigned to an adjuster, and that's when you start coordinating your treatment and your care and the case with the adjuster. You're not dealing with your manager, directly on this claim anymore. Their only role is to report it, document it, and get it set up for you. And they're also supposed to set you up for treatment within 24 hours. And they should know the clinic, at least, that they generally send people to, which is local, and that will set up the care. I'll go more into care in a little bit. In terms of statute of limitations, that is basically how long do you have to file before it's too late to file. For a specific injury, like something that happened on one day, say you lifted something and you felt a pop in your back, that's called a specific injury. You have a 1-year time limit to report it and file it and proceed with the case. If you don't officially report it, as in writing and document it and a file open, it's going to be too late to file it if it's past 1 year. For the other kind of cases, which are cumulative trauma, which is basically the nature of your job, or then it gets a little bit more nuanced, but essentially you should never wait more than a year from when you know that you have a problem and you know it's work related and it's likely to cause a disability. And especially if you're off of work, you cannot file if you've been off for more than 1 year. The adjuster, the insurance claims adjuster, will have 90 days from the time that they receive the claim form to decide, is this work related or not? So they do their investigation. They may interview, they may order records, look at the facts, and then make a decision. You'll get that in the mail, and it'll say, we have accepted your work injury, or we have denied your work injury. And if there's no denial within 90 days, then the law says that it's presumed that it is work related. They have a strict time limit to make that decision. In terms of the kinds of injuries, we can move on to the next slide, please. As I had mentioned, there's specific injuries, which is just the nature of your job. And then, just the a specific thing that happened on a certain day. And then there are very valid types of claim called cumulative trauma claims. And your employer's not going to broadcast this kind of claim that you're entitled to, but everybody knows what it is. You've been working for 20 years. You've been repetitively doing the same thing, bending over, bending down, and your knees are shot now. The degenerative nature of that work over time. That's called a cumulative trauma claim. It's very valid, and a lot of people aren't aware of it. So I want to make sure that everyone is aware that this is a real valid claim in workers' compensation, that the nature of your job over time caused the problems to your back, your neck, your knees, whatever body parts that are involved. Then there's the occupational exposure type cases that you may have, which unfortunately I have had cases where the noxious fumes of a cleaning agent and they didn't provide adequate protection caused toxic exposure, and other types of cases, which I won't go into too much. But psychiatrically, if you feel like you have a psychiatric claim, I can't get into too much today, but call me and I can give you the nuances about it. In short, the law does have extra hurdles for a psychiatric claim. And so you have to prove that over 50% of your problems are due to work and not anything else that's going on in your life in the past or the present. And therefore you do lose your privacy rights a bit, because they get to question you and order records to find out that information. You also have, if it's a predominantly due to what's considered good faith personnel action, which is basically the actions of your manager, scheduling, write-ups, disciplinary actions, bad performance evaluations, those are called in the umbrella of personnel action. And if that's the main source of your stress, it's not a valid workers' compensation claim. You won't win on that one. But it's a bit fact specific. So let's see. And then there's also a time limit. You have to have worked a total of over 6 months before you can file a psychiatric workers' compensation claim. So let's get into the heart of what we're here for. COVID-19, it's affected everybody every day since the beginning of this, and hopefully it will be going away soon, but we don't know. So let's talk about what rights you have. Your union has been working tirelessly to protect you every day as much as they can, negotiating with the companies, ensuring that they're complying with the county and state requirements for safety. And so follow up, check out your union website and talk to your union reps about that if you have concerns about the day-to-day problems that you're encountering to keep safe. From my understanding, every store and company is required to have a checklist of that they are complying with these requirements. They're providing adequate masks and PPE with the social distancing measures, the crowd control, sanitizing and cleaning measures, providing breaks to have proper washing your hands and everything. So you have the right to ask for that checklist, make sure it's posted, and ensure that it's enforced. And their union has been and in short saying ACDC, and that's basically ask that they provide you the safety precautions that you are entitled to, confirm and in terms of what was their position on if they're providing and what is their protocol on that. Document your request in writing, take pictures of the problems that you're seeing, and if they are not remedied, call your union rep for further assistance, the health department, and even as far as the police. You have to protect yourself when you are in this work environment every day. So on the workers' compensation end, with Governor Newsom passing or instituting the stay-at-home order on March 19, obviously there was most of everyone that's tuning in here was considered an essential worker and continued to do the job, your job and providing essential services and food and healthcare services to the community. So in recognition of that ongoing risk, Governor Newsom passed an executive order on May 6th, and that was in large part due to the advocacy efforts of your union and other labor unions and worker rights advocates and attorneys to pass this. It's pretty unprecedented in that it is very broad. It's usually these presumptions, as they're called, are limited to a certain element of the workforce, such as public safety officers or something that is in the labor code. But this one is very broad in that any worker that was required to work outside of their home at the direction of their employer between the date of the stay-at-home order that was instituted on March 19 and then going on for 60 days, that if you were exposed to COVID-19 and tested positive while you were working during that period of time, it creates what's called a rebuttable presumption that it was work-related. What does rebuttable presumption mean? It means that usually in terms of workers' comp, the injured worker has to prove that the work was what caused the injury. So it's the injured worker's burden of proof. Well, with COVID-19, this is an invisible virus, and trying to get that sort of evidence is very challenging. So the governor, in light of that recognition, flipped the burden of proof and said the employer has the burden of proving that there was some certain facts involved with this worker to prove that it wasn't work-related. So unless the company or the employer can prove with certain facts that the judge finds to be substantial evidence, it's going to be presumed to be work-related. So that's different than a conclusive presumption. A conclusive presumption means there's no way that the company can deny it. It's rebuttable, but it definitely is important because it makes it much easier for a workers' comp case to be accepted as work-related. So you have to, for this specific order, you have to have worked between March 19 and July 5th. And you must have been tested positive or diagnosed with COVID-19 within 14 days after physically working during that time period. And if you didn't have an official test done, but it was a diagnosis, perhaps over the phone via telehealth, you have to follow up with a California certified doctor for further testing to confirm that diagnosis within 30 days. The other thing within the executive order is that normally, as I had mentioned, the insurance company has 90 days to decide a claim, but Governor Newsom's order shortens that time period significantly down to 30 days. So now it's 30 days for the insurance company to make that decision. And so for me personally, when I'm representing someone, it expedites everything in terms of the discovery process. They're setting up a deposition and they're talking to the injured worker immediately, understanding that they have only 30 days to make this decision. And so we're still having to working out all the interactions of the language of the executive order, but my understanding is that there has been a lot of government, federal and state and county ordinances and orders that have passed to provide pay to injured workers and so my understanding is that the employer needs to pay based upon those orders, such as the 2 weeks for food chain workers before temporary disability within workers' comp kicks in. And one other detail is that for the first 45 days that you're out within this order, it requires that you continue to see a doctor and be recertified to be off work every 15 days for the first 45 days in order to be eligible for temporary disability within workers' comp. Now, let me just segue off on that because this is what I tell everybody, is that this whole process is going to take a little while. It's going to take a while to file the claim, get it set up, assigned, investigated, decided. So during all of this, you need to continue to see a doctor, and if not through workers' comp, then through your other health insurance for now, and be certified for state disability and apply for state disability through EDD, it's the state of California. You pay into that system. So you have the right to file that and use those funds. And then once once it's accepted, hopefully, and they agree to pay you temporary disability, they will coordinate to switch it from state disability to temporary disability. So you don't get both. They're the same type of benefit, but temporary disability is payable through workers' comp. State disability is payable through the state of California. You've paid into it with your paycheck over the period of your employment. Next slide, please. So once again, you can get the claim form through your union website, and there's also more information about the executive order through the Department of Industrial Relations, which is the state agency that governs workers' compensation and manages it, and then also through us. And we have a hotline there. It'll also be posted at the end, so you can jot it down, get a piece of paper. Between now and at the end of the presentation, you can jot down the phone number and my email address, and you can get in touch with us. So obviously what I've talked about has very certain requirements in terms of the time frame of employment. So things are moving and changing depending on how things go. There are several bills being considered in the legislature right now that will hopefully pass certain more permanent requirements and presumptions in terms of it being work related. So it may extend the time period back, go forward beyond July 5th. It may include certain essential workers or certain critical workers. So we're waiting to see about all of that. So hopefully this executive order will be expanded in some way, either by Governor Newsom or through the legislative process. And you can check it. You can sign up for our newsletters in our website, GEKLAW.com, which will also be at the end. And we can send you updates when these kind of laws pass. But also for now, assuming, hopefully it won't be the case, but assuming nothing else passes, what happens if you were exposed before March 19 or after this order expires on July 5th? Well, then I think that we're back to the normal workers' compensation laws, which is that we have to prove that it was caused by work. But don't be too intimidated by that, because I think the case law says that if we can prove that there was a special exposure due to the nature of your job that placed you at higher risk than the regular population, then I'm pretty confident that I can get it proven as work related. So I think it's pretty obvious in terms of healthcare workers and grocery workers, meatpacking industry workers, that you are absolutely at a higher risk. You are constantly with the general public. There's an increased chance of a risk at your job with grocery workers, with the face-to-face interactions with the customers, being in an enclosed inside space, close proximity with the healthcare workers, also with patient interactions and the packing house industries. as we've unfortunately seen that is a very increased risk and a problem right now with COVID positive exposure. So, and it's not like we have to prove absolutely that we can prove that it was work related. It has to just be reasonably probable that it happened at work. So I wouldn't let that stand in the way of you filing it. Let me see, I'm just trying to keep track of the time. I'm kind of running out. So OSHA has guidelines that we can use also to argue in terms of your risk factors. And there are, for instance, the SCIF, which is one of the largest insurance companies in California, has already personally instituted that they are admitting cases as being work-related. So hopefully all the other insurance companies will not make it such a burden to get it accepted as being work-related. So let me just blow through some of the other sort of benefits and details of workers' comp. Temporary disability, it's a 2-year in general maximum benefit that you can get through workers' comp, but and there's maximum and minimum levels within the labor code. It's generally similar to state disability, but it does stop short when, go ahead and slide down a few. I'm on slide 17, Lisa. Thank you. It does stop short when a doctor issues a final report. And obviously if you go back to work, hopefully. And that's one thing just quickly about workers' comp is that it has nothing, it's not like if you return to work, your workers' comp case stops, no. Unfortunately, plenty of people do go back to work, but they still have residual issues and it doesn't go away. They're still in pain, they're still taking medication, they still have some range of motion issues. So you are still entitled to that last benefit, the permanent disability benefit, even if you do go back to work. Medical treatment, each company has a medical providers network, and it's available online. And so if it's accepted, what I do as an attorney is help guide you through what doctors are seeing, patients, getting that appointment set up, getting the authorization. It's a lot of back and forth, a lot of paperwork, and making sure that the doctors understand how to get stuff requested properly within the system. They have to put it in a form, it has to meet certain guidelines, and in order to get approved. If it's the utilization review is the company that the insurance company uses to have doctors review the request, hopefully accept it. If they deny it, then there's strict time limits to appeal it. And that's what I also do as an attorney, is to appeal these denials with the state of California. It's called independent medical review. So that's all set out in terms of the process of getting treatment. Permanent disability benefits it doesn't mean that you are permanently disabled in the context of outside of the workers' compensation arena. So it doesn't mean that if you get a 20% award that carries on for life and it affects anything else. It's just a way to label the benefits that you're entitled to within the workers' comp system for the fact that the doctors acknowledge you have some residual issues to certain body parts or symptoms. And it's usually they use what's called the AMA guides to rating permanent disability. And so the law says we have to use that. Each chapter has a different body part and guideline. And that's what I do, is to make sure that they're using that guide appropriately, including all the body parts, so that you have future medical care for those body parts. And so with COVID-19, absolutely, hopefully, if you have it, you fully recover. It's too soon now to tell in terms of the scientific literature. Are you going to have, is there going to be residual effects, respiratory issues, or anything else? So just keep in mind that there is a 1-year time limit to file it. Even if you think that you fully recovered, but then you realize you didn't, you have time. It's not too late. You can file it if you realize that you're having ongoing issues, and don't be afraid of that, of filing that. Real quick, in the end, the employer is only responsible for what they personally, what you actually, the injury that was actually caused by work. So if you had a prior motor vehicle accident, that you had back problems and you sought treatment, that's perfectly normal. And then you have ongoing issues because of a work injury, Well, the doctor at the end will just look at the reports, look at the facts, and decide what percentage is due to work. So that's called apportionment. There's a whole process within workers' comp to get doctors' opinions legally, and so that's what I do, is guide people through that process. There's a panel qualified medical examiner that the state has a database to examine and issue these opinions. And also, if you have an attorney, there's a route called the agreed medical examiner, who is a local known specialist that everyone can agree to as a neutral doctor to evaluate these cases. Return to work issue is a huge part of it, and I think that I'm assuming I'll get some questions, so I'm going to hold the details to that. But for the most part, can you go back to work if you have a workers' comp claim? Absolutely. And what determines that? If a doctor says you can go back to work. So it has nothing to do with, and also how long have you been off of work? It has nothing to do with if you have a claim or if you have an attorney. It's really, what do the doctors think you're able to do? Do you have work restrictions? And do you agree with the work restrictions? Do you feel you need them? And can your employer reasonably accommodate those restrictions? So it depends on your job and interactions with that. Death benefits, very important with COVID-19, unfortunately, and they are available. They're set out in the labor code. I can't give the exact details of each level, but it's a whole nother analysis. And what it is did the injured worker have dependents that they supported, and were they considered completely dependent on the person or partially dependent? And the benefits vary depending on how many dependents, if they're under 18, if they're over 18. If they're under 18, then the benefits go on until they reach the age of 18. And there's also burial expenses. So there's also a couple other things to keep in mind. 132A petitions is if you feel like you were discriminated against or fired due to having a work injury or reporting a work injury. And there are interactions with third-party cases, which I won't get into too much detail, but that basically means is there's somebody else at fault for the injury other than your employer. Like if you're driving for work and then you get in a car accident, generally there's a third-party case there if somebody else was at fault for the injury. There's also retraining, supplemental job displacement voucher, which before they had vocational rehabilitation, which was this whole system. But Governor Schwarzenegger abolished that, and way back in 2005. So now the system, what's available is like a tuition voucher, where if you can't go back to your job, they give you a voucher and pay for tuition up to $6,000. And then you can also get additional $5,000 from the state of California, this fund, if you can't go back to work and meet certain criteria. So jot this down. My website, the website for my firm is GEKLAW.com. Once again, my name is Amy Leung. And go to your union website. There's a whole page dedicated to workers' compensation, to the executive order, to COVID-19 concerns. And of course, right now, the union's office is closed. My office, we're all working remotely, but that doesn't mean that we're working any less efficiently. I am available and for all consultations by the phone, by email. But normally after this is, after we open up again, I will be back at Chateau Place Wednesdays, 2:30 to 4:30. We also have somebody up in the Camarillo office, whose office is by appointment. She's there very regularly. And then Al Lizarraga is the attorney that assists in the meatpacking industry, Overhill Farms and Farmer John's. And he's there in the Casa Work Center in Huntington Park on Wednesdays 2 to 4. He speaks Spanish. And I have a legal assistant who is very fluent in Spanish. Her name is Bianca. She comes with me to Chateau every Wednesday. And she's also available to interpret and on the phone for me. So the general office phone number for us is 213-739-7000. There's a hotline that we have set up for you. 888-761-5237. That's our website. Let me give you my personal email. It's Amy, A-M-Y, at GEKLAW.com. That is probably the best way to reach me, Amy at GEKLAW.com. Let's see. Paul, so I think, Paul, is it okay for us to transition to questions now?
Yeah, thank you, Amy. Well, I appreciate that. I would like to just make a quick announcement. So just for anybody, we were holding questions and answers till the end of the presentation. So there is a Q&A, not the chat box, but there's actually a Q&A box on your devices that you've logged into the webinar, especially if you're on a laptop. So there are a few questions in the queue right now, and Amy will answer these questions. Any questions you have, type them in the Q&A box and we will try to answer them live here. It's about 6:36 and we gave this presentation a full hour because we wanted to save about a half hour or so for any questions we might get as well. And if we don't answer any questions online tonight, it's either because we didn't get to them or we may need to refer them to other sources to be answered. So just rest assured that any questions you have will get answered tonight, even if Amy's not able to answer them live on the webinar right now. So what we'll do is I'll go ahead and turn it back over to Amy and we can answer questions anybody have. Like I said, we have a few now. If you'd like to type any more questions into the Q&A box, we'll be glad to try to answer those. And then Amy can turn it over to me at the end and I'll close out with a couple of comments. So.
Okay, thank you. Yeah, so please ask away. If it's mostly I'm the workers' compensation expert, so if you have specific workers' compensation questions, I could answer those. Kim, one of the union reps here, asks, is that what if you get a claim form and from your employer, but the worker knows that she actually got the COVID-19 exposure from her dad who she lives with, and what should she do with that claim form? I mean, I would just really look into the facts. Sometimes someone assumes something, but it's not actually the case. But if it's like slam dunk that you're just absolutely sure you didn't get it from work and you got it from someone else, then you can call in and say, I'm not proceeding with the workers' comp, thank you. And you don't have to do anything else really. They will be happy to close that file. But, you know, I would have, you know, if with these kind of the virus, you can't really be sure. So do the vouchers for vocational training, which is $6,000, expire? Yes, it does expire. I think I have to double check, but I think it's 2 years from the date of its issuance. It should have language there that talks about its expiration. And can't remember, I'm sorry, I have to look at the details, but I think it's 2 years from its issuance. And then there's also a regulation about how much after the date of injury. And then there's also an expiration of applying for that $5,000 from the state of California. So you have 1 year from the issuance of the voucher to apply for $5,000. So don't wait on that as well. And it's on the DWC website exactly how to do that. It's very easy. You just scan in that voucher and then submit it online with the fields and confirm that it was accepted. If you test positive for antibodies of COVID-19, does that count? That's one of the questions. I'm really just relying on the language of the executive order, but my reading of it would be, no, it doesn't count. My reading of it would probably be that it has to be a positive test for the COVID-19 virus, not the antibodies. What's the website I can check to watch this webinar on? At UFCW, Paul, I'm sure there'll be a link, hopefully on the web. Go ahead.
Sure, yeah, I'll answer that one. That's one I can answer, Amy. That's an easy one. So the union's website, and everybody should write this down because we have all of our resource materials for workman's comp and COVID-19 information on the union's website. It's ufcw770.org, O-R-G. And like I said, give us about 24 to 48 hours at the conclusion of this webinar. So I would say maybe by Friday, we would have this online for everybody. Thank you.
There's a question. This is the first time I've been on short-term disability through EDD, which is state disability? Do I pay the money that's being given to me back once I get back to work? No, you don't have to. So when you work, there's already a certain percentage that's governed that you're being deducted through your paycheck and going into this fund for state disability. And that the whole purpose of state disability is that it's a social protection, so that if you were off of work due to any sort of illness or accident or injury, you can get benefits while a doctor is certifying you off work until you go back to work, and you do not have to pay that back. Okay, there's one question that's related to what's considered a cumulative trauma claim. I have been having elbow pain for several years and went to my doctor, and I'm taking medication for several years. It's gotten worse. Can I still file a workers' comp claim? Absolutely. Now, if I would say the only problem would be, like, say for instance, if you stopped working 5 years ago, and then can you file a workers' comp claim? Probably not. But if you just kept working and dealing with the pain and taking medication, you can file it. I don't have a problem with that statute of limitations. It goes all the way up to your last day of work, and I can get around that in terms of them trying to argue that you knew it was work-related years ago and never filed it. For the most part, everybody is hardworking. They just want to keep working until, unfortunately, they can't do it anymore. They have to realize that it's bad enough to file a claim. I started having headaches beginning of June. The doctor put me off for 2 weeks, but I never got tested until June 15. I am positive now, but my manager said since I was off for headaches, it is not considered workers' compensation. Is that correct? I would not rely upon your manager's decision of what is considered workers' compensation or not. That is a common problem, is that the managers start deciding these things on their own, and they're not the decision makers on this. So if you feel that it's work-related, then insist on the claim form. Insist on getting it sent to the adjuster and getting it set up. And if they're not doing it, contact me, contact your union rep to get it properly filed. So the manager should not be the gatekeeper on these issues. I think that you tested positive, and so we can deal with the specific timeframes in terms of whether it's within the executive order, but I think we can probably get around that. So short answer is yes, you can. Can you still open a claim even though you've been paid out for quarantine pay? And that's from David Quezada, one of the union reps here. Yes, you can file a claim. And so if you still say, it's really up to you, really. I'm not going to say absolutely it makes sense to file a workers' comp claim every single time if you just go back to work right away and you have no issues. So say, for instance, you were off, you missed 2 weeks, you got paid quarantine pay, and now you're going back to work. Does it make sense to file a workers' compensation claim? Totally up to you. I'm not going to say yes or no. If you have any lingering issues, or if you feel like you're going to be off work for a longer period of time, you still need treatment, it makes sense. But if you're off and a doctor keeps you off beyond 2 weeks, the employer is only going to pay for 2 weeks. And then you have to, so then yes, you file a claim for the ongoing effects of being off work, medical treatment, and possibly any residual issues. If we get COVID and then spread it to members, family members, how does that work? Good question. Very difficult in this period of time. Everybody is very worried about protecting their family. And I can't say that workers' compensation necessarily is going to answer that. I think within the limitations of workers' comp, you can only get it for yourself. I'm not aware of, being able to obtain additional benefits for spreading it, unfortunately. But I have read articles that there have been movements on a federal level to try to provide additional benefits for people that have been affected. So it's possible that through legislation that will change. What if you were exposed to COVID-19 at work, tested negative, but do not feel safe going back to work for a few weeks because you do not know if someone else carries it? Would it be appropriate to collect 2 weeks' pay due to COVID-19 so you do not contract it and spread it to loved ones, grandparents, etc.? Good question. There's a lot of interactions in terms of other benefits that have passed on an emergency basis. So I would encourage you to look those up. There's the federal Coronavirus Family First Response Act. I can't remember the exact name, and then it was expanded by Mayor Garcetti with who is covered. And then there's also on a state level, they've expanded the paid sick leave for family leave and for, and then Governor Newsom has passed executive orders for food chain workers. So the expansions of benefits available outside of workers' comp for this in response to this virus are pretty broad, but I can't get into too much detail. So if you feel like you need time off of work to care for a loved one, to protect someone, to be extra safe, look into those benefits if you qualify for state disability, for unemployment possibly if you are, if your child is out for school, or if you have to take care of a loved one. So that maybe has that special risk. My one advice in general is to not take off without a doctor's note and without making sure that your employer is aware and consents to all of this, because you don't want to put your employment at risk for being off without following the proper protocols. Well, okay, Jackie, one of the union reps asked, what if a test result comes back positive after July 5th due to a lag time? I think the executive order requires that you're actually worked on a date between March 19 and July 5th. So say, as long as you worked within that period of time, I don't think that when the test result comes back matters. My concern is, and we'll see what happens at that time, but my concern is what happens if you worked, say, 14 days after July 5th, and what happens if you get test positive. But I think we're still okay within this time frame. If a member who's receiving California state disability benefits moves out of state, can those benefits still be collected in a different state? I don't know for sure. I'm not a state disability expert, but I believe it matters what period of time you have funds in the state disability system. And usually they look back 3/4 of a year. So if you worked and paid into the system 3/4 of a year ago, that's what's relevant. So I suppose you may still get it if you move out of state. If I have a workers' compensation case from a fall, should I have an attorney? That's a good question. Whether to have an attorney or not, really, we have to just talk about it one-on-one with you and see where you're at. If you're still having residual issues, if you're having problems with the care that you're getting, if you're off of work. So it really is a fact specific. So you don't need an attorney for every single case. Absolutely, you can file a claim and pursue it and resolve it on your own. And that happens all the time. Most people get an attorney when it's something serious enough that unfortunately they're likely to be off work for quite a period of time. They're having trouble with the medical treatment, getting it authorized, and they may likely have some residual permanent issues. So if you have a surgery, you're likely, unfortunately, to have some degree of permanent issues, weakness or something. And so I help union members in particular when they're having problems with getting the claim going through. They can't reach their adjuster, the treatment's being denied, they can't get treatment set up, they're not getting paid temporary disability, they're denying it. So I don't I don't discriminate in terms of the, you know, what I'm thinking, the worth of it or whatever. I'm just, it's more fact specific. Do you need someone to help you is really the question. And do I think I'm able to help you? Does it make sense to be your attorney on this case? Oh, in terms of the fees, it's 15% of whatever total benefits are recovered at the end, which is the permanent disability. So if you don't owe any fees up front, it's called contingency. So if the end result of your case is you resolve it for $10,000 of value and you get future medical care, which is the standard way to resolve the case, you get future medical care for life and then an award. So regardless of whether you work for your employer anymore, you can take that award and pursue treatment later for those body parts. But the 15% of 10,000 would be the attorney fee. So I think we only have a couple minutes left because there's actually a Spanish version of this being conducted by Al Lizarraga from my office. So I'm gonna hop off in a few minutes so that we can prepare for that. But again, my email is amy, A-M-Y, @geklaw.com. So if you have questions that I could not get to, please shoot me an email and I will do my best. If I can't get back to you tomorrow, I'll get back to you as soon as I can to answer your questions. Also, it would be best to include your phone number so that we can contact you. It's very hard sometimes to answer questions fully by email. Let's see. I tested positive on May 30 and I'm currently in quarantine. I was a worker at Farmer John, so I qualify for workers' comp. The answer is that you qualify for filing for workers' comp. So you should file for workers' comp and then the insurance company has 30 days to make that decision and hopefully they will accept it. For now, I'm seeing good results in terms of them just accepting it without too much hassle, but it depends on the facts. So it just depends, you know, if they find any other sort of evidence that make them think it's not work related. So yes, you definitely qualify for filing a claim and getting it started and hopefully accepted. Will I get paid if I was laid off for 10 days for COVID-19 because one of my coworkers was tested positive and I was working near him? I think I'm gonna have to defer this question to your union rep and your union because I know that they've been working a lot with the details of the 2 weeks pay and when you qualify and when the employer is willing to pay. From my general understanding of it, it seems that your employer, their stance is that they have to have directed you to be off of work and quarantine. But well, short of that, I don't know the details of your situation enough, but I would think that I would definitely follow up to see if you can get those 2 weeks paid for being off work to protect and be safe about not getting COVID and spreading it. Can I file a workers' comp claim on my own without asking my manager? You could. You know, ultimately your manager's going to find out, so it's not like you can really insulate that. If you're worried about one manager, you know, harassing you, maybe you can find another manager or someone up higher that's not going to. You know, it's in general, there are definitely privacy rights, but they're going to know that you have a workers' comp claim. They may not know all the details of it if you go directly to the insurance company, say Sedgwick or whoever's managing it, but they will, you know, interact in terms of your work status and that kind of thing. But they absolutely should not give you an ongoing, you know, harassment in terms of having a workers' comp claim. That's just it's a misnomer for a lot of managers that they think that they're taking it personally for some reason, that you file a workers' comp claim. It's nothing personal against them, the store. It is your absolute right to be protected if you're injured on the job. Are you the only attorney available to help? Want to make sure we get attention as an individual. Also, I have an attorney. Can I consult with you to make sure they are on target? Yes, you can consult with me. I'm not the only attorney that is an option for anyone here. There's a ton of workers' comp attorneys in Los Angeles, and I'm just one option. The reason why I'm here is because we have a longstanding relationship with your union, because they believe that we can help you. And so it's just one option. So you absolutely can seek any other attorney. I would recommend that you only seek an attorney that focuses on workers' comp, not just dabbles in it. And you can also find out if there are states certified as a specialist in workers' comp, which is, many of me and many of the attorneys in my office are, which you have to take a test, to get certified with the state bar. And whether we can substitute in as your attorney, it just depends on the facts and how long, the other attorney has had the case and what are the issues that are going on. So, and where's the case venued at? So it's a possibility in terms of switching attorneys. You're not stuck with a certain attorney. You can switch. Okay, Paul, I think that I don't want
to. Yeah, Amy, I appreciate, I think everybody appreciates all the information that you gave us today. We're just a few minutes short of 7 o'clock. And as Amy mentioned, we're doing this presentation again right after this one ends, but we're doing a Spanish version for all of our Spanish speaking members. So with that, as Amy mentioned, if you didn't get your question answered on tonight's webinar, you can email Amy directly, and she put that out there. You want to give it one more time, Amy, your email address?
Yes, it's Amy, AMY, at GEKLAW.com. And please do give me a couple of days to respond to everyone, depending on how many. I do have some commitments, but I will respond. I can work on it this weekend.
Okay, and with that, I just want to say thank you for all that. We had a great turnout of participants, of our members tonight. We hope that this was educational. By the questions that came in, it seems as though everybody had some very intelligent questions and important questions to ask, and how to protect yourself in this pandemic. So we hope that it was an educational, successful webinar for you all. And with that, we'll say good night and have a great evening.
Thank you, everybody.
Thank you.
Good night.
Bye-bye.